Yes, sir. Do it right now.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and His Honorable Court.
All right, good morning. Welcome to the Fourth Circuit. Delaney, we have more lawyers on the screen than we need.
Yes, sir. Yes, if we can have just counsel for the first case, please keep your videos on. If everyone else can go ahead and mute those until your turn, that would be greatly appreciated. Thank you all.
All right, so our first case is Vapor Technology Associates versus Wooten et al. Mr. Fraser, we'll be glad to hear from you.
Yes, Your Honor, and can you hear me?
Yes, sir.
Thank you. May it please the court. The district court below erred as a matter of law in concluding that 21 U.S.C. 387P, which is the FDCA's Preservation and Savings Clause for tobacco products, limits the scope of 21 U.S.C. 337A, which says that only the federal government can enforce the FDCA. And I'd like to make 3 points in support of that argument today. The first is that the district court misunderstood the purpose of preemption and savings clauses in general. Second, that the district court incorrectly determined that Congress intended to limit the scope of 337A when it passed 387P. And then third, the court incorrectly determined that plaintiff's interpretation of 337A would render the preservation and savings clauses a nullity.
Well, I tell you what, to get started, why don't you talk to us a little bit about standing, because there seems to be some debate about that nationwide in these cases, and obviously there has to be standing, or if there's not, then there's not much else for us to do. So why don't you talk about that from your perspective for a minute? Sure,
Your Honor, and you correctly mentioned that there's been a lot of these cases in different courts and standing has come up. Obviously, we agree with the district court's determination that our clients do have standing. In these cases, the issue really comes down to the injury requirement. But our position is the injury requirement is obviously part of Article 3 standing. And the purpose of Article 3 is to limit the court's jurisdiction to cases and controversies. And if you look at the Supreme Court's most recent statement on this, I believe, which is in the FDA versus Hippocratic Alliance, or Alliance for Hippocratic Medicine, the abortion pill case from a couple of years ago. A unanimous opinion by Justice Kavanaugh saying the purpose of that injury requirement is to make sure that the courts are not issuing advisory opinions. In other words, they're not having parties come before the court that really don't have any skin in the game in terms of what the controversy at issue is.
Counsel, to kind of talk about that a little bit, is it correct that there's no dispute here that the plaintiffs are not in compliance with the federal pre-market approval requirement?
That is correct, Your Honor. That is correct.
So, a lot of the discussion of legally protected interest, I think appropriately questions whether that conflates standing with the merits, potentially. And I understand that and can see how in some cases that's happened. But imagine this situation. Imagine we have federal drug laws and we have state drug laws that are essentially the same as the federal drug laws. And a particular administration doesn't view enforcement of those drug laws as a priority, but the state does. Would someone who's in the business of selling drugs and making money for it be able to say they have an injury in fact?
I'm trying to understand making sure I understand the hypothetical. So I think if any plaintiff that is arguing that a state is violating the supremacy clause of the Constitution, in other words, trying to do something that federal law doesn't allow the state to do, I do believe that a plaintiff there would have an injury. I think it's a stronger case here because we actually have 337A in the Food, Drug, and Cosmetic Act, where Congress is really specifically saying the state, anybody else other than the federal government needs to stay out of this.
Just to interrupt, I think, I just want to make sure I understand your answer. I mean, certainly 337 creates, it helps you on the preemption argument. But the first thing is whether you have a injury in fact when your clients are not in compliance with federal law. And it would seem to me, if that's your position, you would, in my hypothetical, you would have to say the drug dealer has standing.
I think the drug dealer might have standing, Your Honor. I think I look at this and I think the opinions from the Iowa District Court and from the Virginia District Court, which is more recent, in looking at this, and it's complicated, obviously, but the test I think that the states are arguing for here, at the end of the day, really just allows states to escape, implied preemption arguments anytime. Because at the end of the day, the states could always just fall back on, well, yes, we're trying to enforce the federal law, but
Well, couldn't the federal government, if the federal government thought that was happening, would the federal government have any power to say, look, states, you're out of your lane? Does the federal government have any ability to do that on its own?
No, Your Honor. I can speak from experience as being an attorney for the FDA. If the FDA were to face that situation, it could communicate with the states, but I don't know of a court action where I don't know that what kind of claim that would be in front of a court to stop it for an injunction or something like that.
Okay, all right. Thank you.
Thank you, Your Honor. The first point I wanted to make was the district court misunderstanding the purpose of preservation and savings clauses. One of the state's own cases, the R.J. Reynolds versus City of Adena case, which is the ninth.
So counsel, you're done with the standing part, and now you're into the merits of your preemption.
Yes, unless there are other questions on standing.
All right.
Well, and just to make sure I'm making my point clear, is that I think that the issue here comes down to the disagreement is what is the definition of injury when you are talking about whether there is Article 3 standing. And, as laid out in our brief, our position is that injury that requirement is that there is an actual injury to the plaintiff. The plaintiff is suffering some sort of harm, as opposed to a plaintiff who is just a bystander, who is just upset with whatever the defendant is doing. And I think that's when the Supreme Court in the FDA versus Alliance for Hippocratic Medicine laid that out most recently. I think that's the best enunciation of what the injury requirement is. And certainly our clients here, as the district court found as a factual matter, will suffer injuries if they are prevented from continuing to sell various products that are in their inventory.
So why don't, for the rest of your argument, why don't we assume that there is standing? And now you tell us why there's preemption.
Sure. So there's implied conflict preemption, and that is our argument. So the district court relied on the fact that there's a preservation and savings clause. As I mentioned,
Counsel, before you get to the district court's ruling, and I know that's important, but I just want to maybe get some ground rules or understanding. Would you agree that if 337 wasn't there, there would be no conflict preemption?
Yeah, I would agree with that.
Okay.
This is a 337A case.
Well, do you agree that North Carolina could outlaw the sale of these products in its state?
Yes.
do you agree that, I think this is in response to the corollary of my first question, that the combination of this preservation, preemption, savings clause, which just as an anecdote is kind of, an interesting way of, drafting statutes.
Not a model of clarity.
Yeah, a lot of words that, end up with, something probably pretty narrow. But nevertheless, that there is not express, there's not, under just 387P, the North Carolina regulations would be permissible if that's all we were looking at.
I believe we would still have an express preemption argument that this is an effort to adopt a state pre-market tobacco product application.
You're saying that you're arguing for express preemption,
I'm
not
for-
implied preemption?
We have not made that as our primary argument, Your Honor. I think in any case where you're dealing with FDA-regulated medical products, and this is seen in the context of medical devices, and we've cited in our brief, I believe it's a District of Minnesota opinion, but there are also several other courts that do this analysis in terms of medical devices. And the medical device provision of the Food, Drug, and Cosmetic Act has an express preemption provision, which reads almost...
Did you argue this below, express preemption?
No, Your Honor, no.
Okay, so why are we talking about...
Your Honor, I was responding to one of your colleagues' questions and
All right.
in my view. So I don't think the court needs to get there. I think the court can, and to be honest, if our main case is the Buckman case from the Supreme Court. And in that case, the defendant made an express preemption argument as well. And the Supreme Court said, we don't even need to go there. We'll just deal with implied preemption. And I think... Do
you agree that unlike Buckman, we have a presumption against preemption in this case?
I do, but I don't think it makes a difference.
I understand.
Yeah.
But that Buckman's whole really first half of the opinion was about how that was not in the heartland of states' regulation of its citizens' health and welfare. Then it goes on to some issues that I know you cite and I think appropriately do help you. But
Yeah.
just the point is we do have a presumption against extraterritorial, I'm mixing up my case, a presumption against preemption. We
do, Your Honor, but again, it's a talisman that plaintiffs like to use in preemption cases. But I think if you look at the Buckman's progeny, when courts are applying Buckman in other FDCA contexts, and it's typically a state common law tort claim, this drug injured me, this medical device injured me, you still have a presumption against preemption, but courts are still applying Buckman and 337A to those cases. Yeah, the interesting thing about that is, good, I'm glad you brought that up. The interesting thing about a lot of these preemptions, and these aren't, maybe a lot of these cases involve a situation where the state is making a judgment about the federal standard. And there's a risk that the way the state interprets a standard is different than the federal government interprets the standard. That happens in a whole bunch of the cases, and it's even a part of the Geyer case where it talks about the very existence of a implied preemption. And here we don't have that really at all. I mean, whatever North Carolina is doing with the pre-market list is identical. There's no interpretation. It's just doing what has happened at the federal level. Does that make any difference? I don't think so, and here's why, Your Honor. What 337A is saying is that only the federal government can enforce the Food, Drug, and Cosmetic Act. It does not have sort of an exception where, unless the federal government has already decided that the defendant is violating the act. And if you look at the Buckman opinion itself, there was a concurring opinion by Justice Stevens, joined only by Justice Thomas, where they said the outcome would be different here if the FDA had actually decided to take action against the company that allegedly defrauded the FDA. Because then we'd have the FDA just saying, yeah, there was fraud that resulted in the product being approved. But that only got 2 votes. And I think it's, the issue there is the we're talking about FDA enforcement discretion. And the FDA in all sorts of product areas decides that it's not going to enforce in certain situations because it's better to leave certain products on the market rather than take them off. And what the federal government, why it objects to plaintiffs or states getting involved in this is because that gets into the discretion that the FDA has to be able to make judgments quickly and change its enforcement priorities. So that's really the tension here.
Counsel, let me ask one more question. Your time's about over, and
Yes.
I just wanted to ask.
Well, we're gonna take a couple, this is an important case, so we're probably gonna take a couple extra minutes.
Okay, great, thank you. So imagine this, imagine the state isn't, like it is here, incorporating, the existence of a company having a pre-market approval order. It's not, referencing the federal law or regulation as much as it does here. But a state has its own law that that mirrors, not because it incorporates, but it's the same law. Its legislature has gone through a process, adopted a standard that is essentially the same as the federal standard. Maybe it did it first, but we're not talking about an incorporation. Would you say that would be preempted? It's state law and it just either happens to be the same as federal law, or maybe they copied it, who knows, but it's the same standard, but it's not referencing federal law. Would that be preempted?
It would really depend on the precise circumstances, but I will tell you that most states have an FDCA analog. And I believe nobody's ever done it, or they haven't done it in years, but I believe like in the state of California, you can apply for a drug, you can submit a drug, I think, and if I'm wrong about this, I apologize. It's been a while since I looked at it. But you can apply for drug approval from the state of California, but nobody would do that because then you'd be limited to selling it in California as opposed to nationwide. But if a state wanted to, and it set up its own approval process, there would be, it would, again, depending on the precise context, but that wouldn't automatically be preempted, I do not believe.
Okay, but it would have the same effect on the same interference, if you will, with the ability of the federal government to either exercise its discretion or not as this regulation. So it's functionally the same. It's in terms of the actual language, it's different.
I would say it's functionally the same, Your Honor, but the reason it's different, and the reason it's different here, is that the FDA is the agency tasked with using its expertise on the pre-market tobacco product application process, and when products that don't meet that standard, there may be reasons not to fully enforce that. So it is applying its own view of what Congress has done and what Congress wants the FDA to do. And I would say if a state legislature enacts something that's pretty similar, but at the end of the day, it's the state legislature's intent, that would be still, I think you might be able to get around preemption in a situation like that. But again, it would really be context specific.
Well,
the
counsel,
FDCA is very complex. So,
Counsel, let me ask you that, you've already conceded that if the state of North Carolina wanted simply to ban these vaping products, it could do it.
correct.
So looking at the section 387P, A to B, it says that the preemption provision in A doesn't apply to requirements relating to sale, information reporting to the state, distribution, possession. Why wouldn't the language of that statute in and of itself take the North Carolina statute out of any preemption claim?
I'm sorry, Your Honor, could you repeat which subsection?
B. 387
Mhm.
A to B.
Okay. Yeah, Your Honor. So that's the savings clause, I guess it's called, saying that the states retain the authority to enact restrictions on the sales of products. I don't think you can read that as the states are free to then start enforcing other aspects of the Food, Drug, and Cosmetic Act. And here's what I would say about that, Your Honor, is...
Right, but you've said that they can simply ban vape products completely.
Correct.
So if they can do that and they have that power and they're not independently verifying or setting out criteria that a vape manufacturer or distributor has to meet in order to comply with the federal statute, why doesn't this subsection B eliminate a preemption argument?
I would say, and this gets back to, Your Honor, because you still have 387P A2A, where you have the express preemption provision. And again, we're not primarily relying on express preemption, but that is saying that the FDA is the one who has the role in determining whether a product meets that PMTA standard. And we don't believe you can read the savings clause saying that the state can regulate the sales of products to mean that the state can then just, in the guise of a sales restriction, just decide that anytime somebody doesn't meet a provision of the Food, Drug, and Cosmetic Act, that's a sales restriction, because then at the end of the day, you've just rendered 337A a nullity. And I don't think this is an odd way for Congress to render 337A a nullity, especially when Congress passed 387P 9 years after Buckman, 9 years after other courts had started applying Buckman, saying that parties other than the federal government can enforce it.
You could make the same argument that under your theory, 337A renders this 387PB section a nullity.
No, and here's why. I think if you look at the context of the entire Tobacco Control Act, when Congress passed this in 2009, what was Congress trying to do with this preservation clause? The Food, Drug, and Cosmetic Act places limits on what the FDA can do in terms of sales restrictions. So 21 USC 387F parenthesis D says that the FDA may not prohibit the sale of any tobacco product in face-to-face transactions by a specific category of retail outlets. So the Tobacco Control Act is a compromise bill. Cigarettes are bad, but Congress said, well, we're not going to ban them. We're going to limit them. And what the provision I just read said that the FDA cannot adopt a regulation, for example, that says you can't sell cigarettes in a convenience store. Because kids can go in a convience store. But you know what?
Let's see if you can wrap this up in about 20 seconds.
Sure. So those are provisions. That the FDA can't limit the sale of tobacco products in specific retail outlets. But what 387P does is it preserves the state's rights to do that. When the original FDCA said that Congress could, or the FDA couldn't establish a minimum age above 18 to buy cigarettes, but the Preservation Clause allows states to do that. The FDCA says that the FDA cannot ban cigarettes, but the Preservation Clause allows that. So that is what this preservation clause
All
is
right,
getting.
I think we've covered that, and we've gone way over time, so you've got some rebuttal time, so let's hear from Ms. Brennan now.
Thank you.
Thank you, Your Honor, and may it please the court. I'm Stephanie Brennan from the North Carolina Department of Justice. I represent the North Carolina legislative leaders and the Secretary of the Department of Revenue. The district court in this case correctly found the plaintiffs were highly unlikely to succeed on their implied preemption claim for three basic reasons. First, the states have long been the primary regulators of tobacco. Against that backdrop, in 2009, Congress enacted the Tobacco Control Act, which carved out a narrow federal role in manufacturing, but expressly preserved.
So you also say that they don't have standing, and as we noted with opposing counsel, that's a threshold question. If you want to take a few minutes to tell us why you think they don't have standing, then we could move on to everything else.
Certainly, Your Honor. And I would note that there's a good discussion of standing as well in the amicus brief that was submitted on behalf of 28 other states. But the standing argument is relatively simple, and it's simply that the plaintiffs are trying to remove a barrier to illegal activity, and they do not have standing to do so. This is not a case like the cases that they've cited where there's a conflating of the merits of the standing argument, because no matter what happens in this case, that illegality is not going to get
It
resolved.
can't be but so simple, because we've got courts all over the country going both ways, so it must be a little more complicated, at least to some folks.
It's true that some of the courts have not gone along with the standing argument, but I think it's a valid one. It goes back to the concept in the Wright and Miller textbook that you can't try to just remove a barrier to illegal activity because you don't have injury that's recognized by the court when you're trying to engage in something that's illegal, and you also are not able to get redress from the court, because even
So counsel, under your theory of standing, imagine we're in Colorado and a dispensary sells marijuana to only white people. Is there a claim there if selling marijuana is illegal under federal law?
Well, I think they would not be trying to remove a barrier to their own illegal activity if they were trying to challenge that discrimination, which distinguishes this particular case. They are trying to ask this court to remove a barrier to them that would then allow them to do something that's illegal. You know, it would be different.
Well, it's illegal. I guess the point you're making is that it's legal in Colorado, but it's not legal in the federal law. Implicit in that, though, is the notion. I guess the reason I ask that is that if the question is whether it's legal under federal law or not, you would have that similarity, wouldn't you?
That would be similar in that way. And then, again, I also want to address the point that was made about not being able to challenge this. I do think the FDA might have an opportunity to try to bring a claim if they thought that there was some kind of improper thing happening in terms of the state doing something that was preempted. And in addition, this could be a defense. There could be a preemption to defense to any enforcement actions. So there are ways that it could be brought. It's just that the person who's engaged in the illegal activity doesn't have standing to bring a claim that then tries to remove that barrier to their illegal activity. That's the point of our standing argument.
Counsel, you brought that last point you made about whether the federal government could do something. Is it relevant? I'm moving into preemption a little bit on this, but and this is maybe not the central point, but does it matter whether the federal government takes a position or not? I mean, it's kind of interesting. We're talking about interfering with federal government. And one way to look at it is just to look at the law, the statute coldly without anything involved. But, the government hasn't, filed an amicus brief. It's made some comments about why it's not enforcing. It's subjected to the International Trade Commission doing anything. Has the federal government, since this act has been in place, or since North Carolina's done its legislation or other states, even in the press, said this is causing us problems. And does that matter?
Well, first, no, they have not done anything to that effect. And in fact, they've suggested that what the states are doing is consistent with what they want to do because they've gone after and tried to enforce against these products, including some significant seizures of product that have happened in the last couple of years. But secondly, I don't think it matters because what's important in a preemption argument is whether or not Congress preempted and intended to preempt the statute, not what the federal agency wants to do. And here, they have not met the high standard of showing that Congress had an intent to preempt. In this case, recently the court in Gen BioPro said that there's a very high level of clarity that's required and we can't go searching for some kind of congressional intent that's not expressed. And here, we have a very clear statute, 387P, that makes clear Congress's intent when it, in 2009, enacted
It
the
seems to me like it actually helps you that the federal government has not said anything or done anything to impede your statute, because to me that indicates the federal government doesn't think that North Carolina is interfering with its statute, with the federal statute. So I think it helps you.
I agree, Your Honor. I think that certainly there's...
Okay, because you said a minute ago, I thought that it doesn't make any difference, but...
Well, I think certainly it defeats the argument that they try to make about somehow we conflict with federal enforcement priorities, if that's even a valid way to suggest that there's preemption. But I think the primary inquiry for the preemption analysis should be the intent of Congress, which is expressed through 387P quite clearly, that they intended to leave this authority to the states to regulate sales and only to carve out a small area for manufacturing for the federal government. And this particular statute from North Carolina squarely falls within sales. As
So,
your
counsel, I mean to cut you off. I think you explained why you think 387P, its role in this process, and let me just assume, I think if we're looking at 387P, you have a strong argument. What I want to talk about, I guess, two things, mainly 337A. Why in the lead in to 387P, I don't have it right in front of it. It says something like nothing in this subchapter shall be construed to prevent states from doing this, and then it goes on and has the preemption, and it goes on with have the savings. But that nothing in this subchapter doesn't include 337, because 337 is in a different subchapter. And so, and then 337 has some, has a section B that says, there's these things, you can't states enforce federal law, but we got some exceptions to that in B. And it seems like, to try to harmonize those, that's a weakness in your argument. Congress didn't put 387P or the tobacco part of this in 337B, and they didn't mention 337 at the beginning of 387P. That's a lot of statutory terms. I hope you're following me. But you see my point? There's no, I got you 387P if we're just looking at that, but how does the structure of 337 and the beginning of 387P not, work against you there?
Well, I have a lot of answers on 337, but I'd like to address your second point first, if I may, which is the subsection B, the Nutrition Labeling and Education Act, which is a totally different approach that Congress took to a different product, where they actually do allow states to enforce the FDCA in particular cases having to do with food and food labeling. So that's just a different approach, and that I don't think is applicable here. Right. In terms of 337A and how it gets reconciled with 387P, 337A is very narrow, and it merely says that all proceedings for the enforcement or to restrain violations of the FDCA shall be by and in the name of the United States. And that can be given full force and effect when it's read narrowly, consistent with 387P, because the state here is not enforcing the FDCA. The state, of course, could not come in and bring an action and say, we are bringing this case to enforce the FDCA, under the FDCA, to enact the penalties that are allowed by the FDCA. The state, of course, cannot do that. What the state can do is pass its own state law, as it has done, that is not a proceeding to enforce federal law. It's a state-level sales ban. It simply sets as one criteria for sales based on federal law. As a part of that, something that regulates sales within North Carolina. It's not attempting to go into interstate commerce and operate on the realm that the federal government does. It's simply banning these sales within North Carolina using one criteria. The Graham case from Mississippi, the Wisconsin case have all rejected the idea that 337A applies at all here because there's not an attempt to enforce federal law. The state, if it ever takes action.
Counsel, let me interrupt you. I'm sorry for that. And I have read those district court cases, and there's some, I guess, that go the other way. And I think I hear you there, that if you maybe could read 337 as a restriction on states being essentially deputizing themselves to be the attorney general or the head of the FDA and going out and enforce only that federal law. But that, has a court viewed 337 that way outside of these recent district court vape cases?
I don't know that it's been raised outside of these recent cases in that same way, because the important thing here is tobacco specific, right? It's how 337A.
Yeah, but I mean, that's not. I don't think that is with all due respect, I don't know that is the important thing. I mean, we're in the tobacco context, but 337A, as you say it reads, and I think I understand your argument. I think the district court ruled that way. But that does seem a little bit different than the way Buckman and the other cases have viewed 337. They seem to be looking at whether you're incorporating the standards or not. So, I mean, that argument, I'm just asking you, is it in tension with Buckman and, first of all?
And I'm glad you asked about Buckman. Buckman is not applicable, as these other courts have also found. And the reason for that is that Buckman involved a personal injury claim by a private party and an attempt to police fraud on the FDA using state tort law. It did not involve a law that was expressly preserved and saved in a different provision of the statute, which, as we have.
But counsel, that is totally true. And on the point we were dealing with is the way you read 337A. Doesn't the way Buckman treats 337A deal with the way more similar to what North Carolina is doing here, as opposed to reading it just to prevent many states being the deputized attorney generals? I
think that the Buckman line of cases primarily doesn't get to the states being attorney generals. It's mostly dealing with claims from private parties that are trying to assert state tort law, not a state that's asserting its own law. And I think the distinction is a couple of things. One, you don't ever have to adjudicate whether there's been a violation of the FDCA, which is really the thrust of Buckman and what it was concerned about, where the state's just incorporating one aspect of federal law and therefore can't be in tension with it. That's never going to happen. And you also, so I think those are, the Buckman cases don't really even come into play, setting aside some other important distinctions with Buckman, including that the medical device context is a different context in which there was much more federal preemption and stronger federal preemption, which I think was flavoring and coloring those decisions. The preemption clause there was much broader. Regal, the Supreme Court case in Regal, talks about the oversight that there was intended to be in the federal context in medical devices, which doesn't exist in the tobacco context. And so I think that's just those are very different cases that haven't been extended to the tobacco context for good reason, because it's quite distinguishable. I would also point out that North Carolina doesn't initiate an enforcement action under the FDCA, and nor could it when it tries to enforce its own state law, because noncompliance with the federal act itself is not an actionable basis for them to do so. Any claim that they're ever going to bring is going to relate to and be tied to sales, as the district court noted. And so it's not an attempt to enforce the FDCA, it's an enforcement of the state statute that is a sales ban. And I think it would be odd, as I think Judge Agee noted, that they could ban entirely the sales of tobacco, or these vape products, but they're not allowed, and they could also not do it at all, but they can't, and anything in between, so long as they don't mention anything about the FDA or FDA approval status, and that doesn't really make sense. What Congress intended to do.
Counsel, I think that's an interesting point, and it raises an issue I have, which is when we're looking at preemption, I mean, it seems like some of the cases talk about it, I would say, kind of in practical or functional terms. How much is this actually interfering? And then some courts seem to be talking about it way more sterilely, or if that's the right word, just like as a matter of law. Do we just look at the statutes and see whether the statutes themselves conflict? Does that make sense, a distinction between the effect of the law and the just, literal black and white of the law? And if it does make sense, are we permitted to look at practical or functional conflicts, or is it just legal?
So I think it does make sense, and I think there is some confusion and inconsistency potentially in the case law between whether you just look to what Congress did or whether you look to the effect and sort of how it interferes potentially with federal enforcement. It seems to be narrowing a bit potentially in the Kansas versus Garcia case. The Supreme Court rejected the concept of conflict preemption based on federal enforcement priorities, for example. In the Gen BioPro case, this court recently narrowed, I think, the scope of preemption and made it a high standard, and you have to show high clarity, and sort of pointed to, also rejected this concept of conflict with federal enforcement priorities. But I would say I think both of those factors, as Judge Thacker pointed out, favor us here. Even if you do get to the federal enforcement and look at what the federal government has done, there's nothing that would suggest that we're doing something that conflicts. And that can't be the case where we're simply incorporating an aspect of federal law. I mean, it would be far more disruptive, arguably, if we would have gone in a different direction and done something totally different than what the federal, what the FDA did in terms of approval status. That's not what we've done. We've been more consistent. In that way, it would be odd to invoke conflict preemption to say that somehow we've violated and are preempted by federal law in that circumstance. Just want to turn to a couple of other points. Counsel on the other side talked about that we could do anything in the guise of sales. I don't think that's correct. I think that the narrow preemption provision in 387P does have some guardrails for that. And the U.S. smokeless tobacco case addresses that and talks about that you may have to draw some lines sometimes, and it may not always be easy, but where the line is drawn is a manufacturing versus sales distinction. If we were trying to regulate and add something that's different to or in addition to what the federal government has done in those narrow categories in the preemption provision, we would not be allowed to do that. But we're entirely focused on sales. That is not the case. And we've acted fully within the scope of what we're permitted to do. I did want to point out that 28 other states, including all of the other states within this circuit, have asked that this court support North Carolina's position here. This is important. North Carolina is regulating dangerous and addictive products that have been shown to bring a lot of youth users into the market. They try to falsely market their product as safer, and they suggest that these should be allowed in order to allow adult users to have products to leave the market. But The North Carolina General Assembly was entitled to conclude that that is not the case and that the risk that we bring new users into the market far outweigh any potential benefit, particularly given that there's other products available to help people quit. And I see that my time is up, Your Honor, so unless you have any other questions, we ask that this court affirm the district court's denial of the preliminary injunction.
All right, well, we gave opposing counsel quite a bit of extra time. If you feel like there's something essential to your argument that you haven't covered, you can mention that now. Not required, but up to you.
Thank you, Your Honor. I think I would just ask this court to affirm, and thank you for your time.
All right, thank you. Mr. Frazier, you've got some rebuttal time here.
Thank you, Your Honor. Can you hear me?
Yes, sir.
Thank you. I'll just make a few points. Judge Thacker, on your question about the FDA not weighing in, I would just say from a practical matter, based on my own experience, including writing amicus briefs for the FDA, typically does not happen at the district court level. It did happen in the ITC situation that we did cite in our briefs below. But I will tell you as a practical matter, that's not uncommon in ITC cases because the ITC will actually directly contact the FDA and ask the FDA to weigh in.
They didn't weigh in on this appeal, did they?
No, the FDA has not weighed in on any appeals regarding these state registry statutes.
Yeah. That's my point.
Just so the court is aware, North Carolina's counsel didn't bring it up, but they cited the Fifth Circuit's Zyla opinion quite heavily, and that deals with whether a state can simply, by statute, just adopt the FDA standard. That is now on cert petition to the Supreme Court. The plaintiff in that case, the plaintiff that was arguing against preemption, originally declined to file an opposition to the cert petition. The court asked for a response. And then after the court got the response from the plaintiff, the court has asked the Solicitor General to weigh in.
Counsel,
Yes.
but thank you for that on Zylo. Back to the point you mentioned earlier, you explained maybe why there's an absence of a position taken by the government here. I think when I addressed that with your colleague, I asked whether that has legal relevance. Do you have a case that says whether or not the government has expressed anything is relevant or not? Is there anything that addresses whether we should or can consider that?
I just think in general, obviously the courts have the final say on what's constitutional and statutory interpretation, and the executive branch views on that is relevant. The court can take that into account.
Okay.
But it's no different than any other amicus. So I want to talk real quick.
Do you have, can I ask one more question
Sure,
before
absolutely.
you go to your points? I'd asked your colleague, I'm not sure how artful I did it, and it's kind of hard thing to explain, but whether we look at preemption from the practical effect of a conflict, or whether we look, kind of more from a binary standpoint, is it in conflict or not based on the letter of the law? Do you have authority that says how we do that, whether we can consider the practical effect, how much of a conflict it is, things like that?
Sure, Your Honor. I think you used the term a sterile version of it, and I can't remember what the other one is. And, I would go with the sterile version, where
I'm sure you would,
especially when.
No
when
offense, I don't blame you, but I asked you, not really your view on that, but whether you have a case that helps me with that.
I don't. Again, I would go back to Buckman, and I don't know if this is Buckman is really a sterile version, but Buckman is looking at the entirety of the Food, Drug, and Cosmetic Act and the medical device approval process, and is taking into account in general how that works. Taking into account that the FDA has to, and traditionally does, engage in enforcement discretion where it does not, for whatever reason, fully enforce various aspects. And this happens not just in the tobacco context. I will tell you that during the pandemic, the FDA issued tens, if 20, 30 guidance documents saying, here are provisions we are not enforcing because of this public health emergency. We think it's more important for products to be on the market. And I think what Buckman recognizes is that also occurs in the medical device context. And that is really where this comes down to, is where I think the courts need to look at this, is that you have to look at, in this context, what the FDA does, what its role is, and the fact that you've got 337A, which gives it that enforcement discretion. And when you are intruding on that enforcement discretion, that's it. And you don't have to, there is no sort of gauge as to, well, how far are you intruding into that enforcement discretion? Because I don't think that's a workable standard when you're dealing with public
All
health
right,
issues.
Mr. Frazier, we've been very liberal with you in time today, so if you've got something else that's you think's crucial to your case, you've got about 10 seconds to tell us.
I do not, Your Honor. Thank you very much for the extra time. I appreciate it.
All right, well, we want to thank both counsel for their excellent arguments today, and we're going to take this under advisement and issue an opinion in due course. So ordinarily, we would come down from the bench and greet you, but obviously, we can't do that with our virtual court. So hopefully, you'll come back to the Fourth Circuit another time when we can. So with that, Delaney, we'll take a minute or two stretch break before we go to our next case.
Thank you.
All right, thank you.
This honorable court will take a brief recess.
case, I think.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Our next case is Lau versus Kay. Ms. McGill, do you have some student counsel for us today?
Yes, Your Honor. Good morning. My name is Lori Alvino McGill. I'm from the Appellate Litigation Clinic at the University of Virginia School of Law. And I'd like to introduce two of my students this morning, Madeline Forbes and Margaret Fox, who will argue as amicus in support of the appellant, Mr. Kay.
All right, we're glad to have them. I assume Ms. Forbes is going to do the opening and Ms. Fox the rebuttal.
That is correct.
All right, Ms. Forbes, we're glad to hear from you.
Good morning, and may it please the court, Madeline Forbes, amicus curiae in support of defendant appellant Ben Kay. Plaintiff's complaint alleged that Kay took $400,000 from her without any authorization, and that she was unaware of Kay's taking for nearly 9 months. Plaintiff suddenly claimed for the first time at trial, however, that she was aware of and actually authorized the transfer of the funds at issue, but based solely on the condition that the parties would get married. Plaintiff alleges in its briefing that there was no shift in theory during litigation, but a comparison of the allegations in her complaint to those at trial demonstrates the seismic shift that culminated in a novel factual theory against Kay. Rather than amend her pleadings prior to trial, plaintiff instead attempted to amend for the first time during trial. And in permitting her to proceed at trial with this novel theory, the district court abused its discretion in violation of Rule 15b, grounds upon which this court should vacate the district court's judgment and remand for further proceedings.
So, counsel, can you talked about 15B. Are you talking about 15B1 or B2?
Your Honor, we are addressing both 15b1 and 15b2 because neither provision permitted amendment in this instance. If we begin with 15b1, their amendment is only permitted once a party has objected if that party will not be prejudiced. Here, the record demonstrates that Kay sufficiently objected. He said, in the testimony, they changed to say the transfer was authorized, but it's based on some attachment to my house. I've never heard that before. He said, Your Honor, if it's not about unauthorized, what's this claim? They fail to state their main legal claim. Pro se litigants, as this court has recognized, are entitled to have their objections construed liberally, and for this reason, Kay did not need to use any magic words like prejudice or even...
So how much slack do we cut Mr. Kay here as a pro se litigant? I mean, we often get pro se litigants who are impoverished or for other reasons aren't able to obtain counsel, but it looks like on the record here, Mr. Kay is a person of some means, and he made a calculated decision that the lawyers he talked to were just too expensive. So he seems like he made a very clear economic decision that he was going to proceed without a lawyer, and so there were some mistakes made. Why does he get to get a do-over when he's made this choice?
Your Honor, it's almost as if he didn't have a choice. The lawyers available to him, he stated to the court, were too expensive for him. And he did choose to proceed pro se, but under this court's precedent, it's expressly recognized the leeway that is to be afforded to pro se litigants. And one such leeway is construing their objections liberally. Now, I agree that
So are you arguing that this was a constructive amendment of the complaint at trial?
Yes, Your Honor, it was a constructive amendment that was not permitted under Rule 15b. Just to return to 15b1 for an instant, because Kay objected, amendment was only allowed to proceed if there would be no prejudice to him. And while there is a little precedent on 15b in this court, there is much on 15a to show that Had this amendment been sought before trial, it would have certainly been found to be prejudicial. So the fact that it arose during trial should lead this court to believe that it was more incredibly prejudicial.
You seem to argue in your briefs that there was a sua sponte duty on behalf of the district court to construe Mr. Key's comments as an objection and to fulfill the requirements of Rule 15, but I'm not aware of any case that imposes that duty on the district court.
Your Honor, it's not a
Have
duty.
one?
No, Your Honor, it's not a duty under Rule 15B. It was merely that in allowing the amendment to proceed in violation of Rule 15B, in order to prevent the ultimate due process violation that occurred here, the court should have taken it upon itself to order a continuance. Had it
So-
ordered,
Counsel, can I follow up on Judge Agee's question and Judge Thacker's question? Well, I understand, I think, your argument that your client effectively objected, and we can look at that issue, but just hypothetically assume we don't agree that he objected. And this question is just I'm trying to figure out what happens then. If he did not object, and there is the evidence presented is outside the pleadings, what happens under the rule then?
Your Honor, what happens then is we move to Rule 15B2. If you do not find that he objected, it would be effectively finding that he consented. We do not agree that he consented expressly or impliedly, but regardless, under Rule 15B2.
Consented to what? A motion to amend that appellee never made? Appellee never sought to amend, correct?
She never sought formally, but Rule 15B seems to contemplate that no motion would be required. If there's consent, the pleadings are effectively, constructively amended. But regardless of whether B1 or B2 is applied, what was required at the end of the day was that there be no prejudice. So even if this court does not believe that he objected sufficiently and looks to consent under B2, amendment was nevertheless not allowed. Again, this court's seen.
So that's, I'm just trying to, I think you have a good argument that, he didn't consent, although, we'll hear from the other side on that. And you have an argument that he didn't, that he did object. I'm wondering though, whether, if he didn't object, and is the effect of that the district court has to be aware of what the pleadings say and whether the evidence submitted is outside that, and bring this issue up on its own? Because if we rule for you, we're saying, I think in effect the district court did something wrong, and I fully get it if you objected. But if you didn't object, it feels like the district court has some sort of roving duty to be comparing that, and that seems like a tall order to place on district courts. Does that make sense? Do you understand what I'm saying?
I understand your question, Your Honor, and it is important here to, again, emphasize that we do believe he consented, so we do not believe.
You mean he objected?
That he objected, excuse me.
That's okay.
But B1 and B2 draw a dichotomy between objection and consent, where B2 contemplates implied consent, but you could find you can't even find that here.
Didn't during the jury charge, didn't appellate actually specifically address the court and say, I've been fighting all these things the whole year, but to my surprise, during the plaintiff's testimony yesterday, she said that's authorized, so she changed a major claim. Isn't that bringing it to the attention of the court?
Yes, Your Honor, that's further evidence.
Directly, not just in his testimony or closing argument or opening statement, even though he said it there too.
Yes, Your Honor, exactly. That is further evidence of his objections to plaintiff's amendment during trial.
And counsel, following up on that, not only did he bring it up, district court there, I think, said, well, that only applies to conversion, but that same position he made it would apply to the remaining cause of actions too, wouldn't they?
Correct, Your Honor, they would.
In other words, if that is sufficiently bringing to the court's attention, I don't know how that answer would be correct.
Correct, Your Honor. The district court's proceeding was an abuse of discretion, given that neither of these provisions were satisfied. Certainly that he attempted to object and bring to the court his inability and unpreparedness to continue, given these new allegations.
How do the evidentiary rulings fit into your argument? Because, I've looked at those and, let me just say, I find it hard to see how at least the rulings on, I think exhibits A and B aren't, I see problems with those rulings. Let me just say that. How do those evidentiary rulings impact what we're doing?
Your Honor, we mentioned the evidentiary hearings for two reasons. First, we wanted to bring to this court's attention that after the Rule 15b violation and after the due process violation had been cemented, there were concrete innate powers that the district court possessed such that it could have helped Kay make up some of that ground that he lost, given that the theory of the case changed underneath his feet at trial. And so that's why we mentioned that many of these pieces of evidence are easily admitted under many of the exemptions to hearsay. And
Well,
Why don't you just say that was an error and it was reversible, just on the evidentiary rulings alone? It doesn't seem like you come out and say it that way. Maybe you're saying it in so many words. But is that your view?
yes, Your Honor, that was my second point, is that those are sufficient grounds for this court to reverse what occurred below. But again, the evidentiary issues that occurred here.
Even if we assume you're right, and you may well be, what's our authority to consider the evidentiary questions now? I mean, there was no objection. There was a lot of discussion about evidentiary rulings, but how was the district court on notice that it was supposed to correct its rulings?
Your Honor, that would require a plain error standard of review, and we do believe that he can still satisfy this standard of review.
Well, it may require fundamental error as opposed to plain error based on the status of the case. And that's kind of what we're grappling with here, is that, you've got some very legitimate issues. But we're grappling with, maybe Judge Quattlebaum was the one who asked this. How do we say that what the district court did was wrong if we're going to reverse it?
Your Honor,
on the evidentiary issues.
Your Honor, I think the narrowest option for this court to reverse is to find that there was a 15b violation that amounted to an abuse of discretion. There are additional evidentiary issues, and there was an ultimate due process violation, but it's sufficient for this court to find reversible error alone in the 15b violation. And for that reason, we ask that this court vacate the district court's judgment and remand for further proceedings. Thank you.
All right. Thank you very much, Mr. Chang. We'll hear from you now. Mr. Chang is on mute.
Apologize, Your Honor. Good morning, Your Honor. Xiaoming Chang on behalf of Ms. Lai. I'm representing the appellee. Your Honor, so I want to address several issues. Can you hear me? Looks
Yes,
like
sir.
I can speak. I need to speak a little bit louder. I apologize. So it looks like I need to address several issues. But first issue I want to address the standard of review. Looks like the opposing counsel said lots of words about abusing of abusing power, due process violation. All those under the Fourth Circuit precedent the standard of review should be abuse of discretion instead of the review standard they requested in their brief. They asked for de novo review.
What was
Counsel-
what was your breach of contract theory at trial?
Your Honor, this goes to the breach of contract. Your Honor, the breach of contract is that whether they had some kind of oral agreement regarding the fund transfer. So from get-go, we know this is a tension.
Based on
But
what?
that was
No, what
yeah.
was your breach of contract theory at trial?
The breach of the contract theory is that there are certain kind of agreement among those about how the funds going to be used. What's the purpose of the fund?
All right, well, so what was the breach of contract theory that was pled? Not what you raised at trial, what did you plead?
Yeah, what I plead is that the breach of contract is that breach her, confidence and breach her, his confidence on him, and therefore the fund transfer was not authorized. That's what I plead in the breach of contract claim.
Well, I thought.
And that's not the theory you went to trial on, is it?
That is not the argument I made during the trial. Yes, Your Honor. But does that work in the other side's favor? Look, so what I did is, the plaintiff concede a key.
All right,
fact.
so you agree you changed the theory at trial.
No theory was changed. The question remained the same.
Well, you said that. Yeah. Well, what contract did you argue was breached at trial?
The contract was breached at trial is that what basically fundamentally what the fund was for, and then she gave.
No, wait. Didn't you argue at trial that she paid off his mortgage because they were supposed to get married, and since they didn't get married, he needs to give her the money back? Is that what you argued at trial?
Yes, I did.
Okay, so where is that in your complaint?
It's not in there, Your Honor.
Okay, so the theory did change at trial. In fact, not only did it change, your appellant admitted at trial that the funds that the complaint asserts were unauthorized were in fact authorized, correct?
Well, appellee admitted that.
I'm sorry, appellee admitted that. Thank you, Judge Agee.
I think we made concession about what's the funds for. Actually, that
Right, but your pleadings, counsel, your pleadings in discovery before trial were that there was some sort of a financial investment scheme and funds were transferred to Mr. K for investment purposes, and those were unauthorized. There's no mention that I'm aware of anywhere in the pleadings or in any of the pretrial discovery of this oral contract for marriage. I mean, is there someplace you can point me to in the record where we would find that?
No, there was not, Your Honor. You are correct.
All right,
So,
so
counsel-
it looks like to me we have to start with that there was an amendment that's cognizable for purposes of Rule 15b1. So what are we supposed to do at that point?
Well, Your Honor, I think at that point, there are several ways to do that, right? The court, he can make an objection, and then he can ask for continuance, and at that time, probably the court will give to him. And also, I want to point out,
If he would have had a lawyer, all those things might have been done, but he obviously told the district court, hey, look, this is completely different from anything that I've seen before. I mean, he didn't ask for a continuance, and that was a mistake on his part. But it's clear he alerted the district court that this is a new ballgame. I don't know where this is coming from.
Yes, Your Honor, he did. But, again, as you pointed out earlier, the court afforded him, advised him again, he's entitled to counsel assistance. And then he chose to represent himself. And then if he did object,
Well, should also be entitled to a fair trial, and that opposing counsel and appellee won't change the theory in the middle of trial.
Again,
So
Your
do you
Honor,
not, so
yeah,
to get to back to Judge Agee's question, since assuming that the complaint was constructively amended at trial, what are we to do with that?
well, I think what happened next is that the court, the court allows the proceeding to the trial to continue, and then he has the equal opportunity to present his own evidence. And I do believe that my concession actually works in his favor. He won the fraud claim, and then he could probably won other two claims too, if you know how to use that point.
Counsel,
me-
wait a minute. Judge Quattlebaum's got a question first, so let him ask it and then you answer it.
Yes, Your Honor.
So I appreciate your answer that you say this may have helped him or not harmed him, but this is a very specific question. Do you have a position on whether Mr. Kays objected to the amendment to the amendment of the pleadings?
Your Honor, could you repeat it one more time? I do not fully understand
Yeah.
the question. I apologize.
That's okay. Your opposing counsel says that his conduct was enough to amount to an objection to you using this new theory at trial. Do you have a response to that?
Yes, I do, Your Honor. I think if let's say, I don't believe I had a new theory, but let's say I did. I do not, Then I don't think it in any way prejudiced him. Actually, it made his case stronger. He could have come up with much stronger with the...
Could I interrupt you? I understand your prejudice argument. What I'm really trying to get at is, do you have a position based on the way Mr. K responded to the way the trial went, whether he objected or not? I mean, he might not have used the words objected, but as Judge Thacker said, he questioned some jury charges. He tried to do a second opening statement. He expressed confusion. Is that an objection or is it not an objection? And tell us why, using any cases that you have that help you.
I don't think it amounts to an objection. Objection would be very clear, tell the court that I don't want to proceed, I need more time, I need more preparation. He just acts confused. I mean, I don't blame him, but I don't hear any objection. And I don't know at that point, the posture of the court, what the court needs to do. So the argument is that the court should stop the case voluntarily and, give him more time. So it looks like the other side arguing the court should, on behalf of him as his counsel, but at the same time make a ruling. That's my position.
Judge Thacker, did you have a question too?
I don't think so right now.
Okay.
Well, actually, I do. Doesn't the court have an obligation to ensure a fair trial?
Yes, Your Honor. May I continue, Your Honor?
Yes, go right ahead.
Yes. So I think let me go back to the what happened that day. Probably make the things much more clear. So at that day, I volunteered dismissed the two of the complaint, the conversion claims, the conversion, the breach of fiduciary duty. After that, and then the judge Davis asked him whether he consented to that or not. He said yes. So two of the claims are gone. With those two claims are gone, then at that point, the plaintiff decided that there's no point to continue to argue whether there's a consented transfer or not, because both sides and the facts support that there was a transfer. So the only thing we need to find out during the trial is that was there a relationship or what's the money for? And this is the open field. He can arguing that money is for the dating expense. They can argue that money is for they can make a common donation. I mean, the court does not in any way prevent him to arguing to put on his new case. He still can put on his defense, and he still have all of. And during
the discovery and the pleadings, particularly the motion for summary judgment and everything leading up to the trial, had nothing to do with what you're talking about now and what your theory was at trial. So how is it not prejudicial to appellant to have to defend against a whole new theory? I don't see how that helps him, as you say.
Your Honor, if you say he's prejudicial, I don't believe so, because he still have all the options. Actually, as I said before, I think my concession or all concession made the case stronger, right? But again,
I know you say that. You say that. But I don't think he agreed with that. And if you would stop talking when I'm talking, that would be helpful for me.
Thank you, Your Honor. I apologize.
I lost my train of thought. Go ahead.
Well, I mean, then I need to ask my own one question. What could I do at that point? The trial.
Well, you could have made a motion to amend, because that's what you were doing, was amending the complaint. So you could have made a motion to amend, and then the court would have taken the proper steps to determine whether your motion would be granted or not, and whether a continuance was warranted at that time.
Yes, Your Honor, I apologize. I did not do that. And at this time, I think the court is ready, everybody's ready, my witness is ready, she's ready, so we proceed. And
not everybody's ready, because appellant wasn't ready. The appellant was ready for the prior theory. Appellant wasn't ready for the new theory. That's my point.
Your Honor, if we could go back to the time he made an objection and the court granted continuance and ask us to come with a new amended complaint and come back with a new trial, I would agree that too, Your Honor.
Right. I think that is your, perhaps your strongest point is that there wasn't a clear objection.
Hold on a second. Say what you just said against Mr. Chang. Did you just say you were consenting to sending it back for a new trial? I just didn't understand what you said.
Your Honor, I apologize. I probably confused you. I said that if we could go back to time and then he made an objection, he wanted to have time to continue the case, he wants the case to be continued, and we come back on a new date, a new court date, which on the Eastern District, which is very strict about the trial date and there's no change of trial date, then I would agree. I think I would agree that yes, we could come back another day. But at that time, we are, I think, both sides under the pressure that the case has to go forward. So I go forward with the case.
Well, so following up on Judge Agee's point, if we find that he did sufficiently object by bringing this to the court's attention multiple times, then you would agree it should go back for a new trial.
If you order that, yes, Your Honor, no problem.
Okay.
But again, I agree that if he entitled to.
But you just don't agree that he sufficiently objected, correct?
I don't think he objected. I don't think the court should play the role both, act on his behalf and be a judge. I don't believe that in this entire process, he's being prejudiced in any way. I think he presents strong case. He won on the fraud claim. Actually, he won because all concession. So I think, in a sense, I think we were when trial started, because all concession, we are actually at a weaker position than we begin with the case. But there's no ideal world, Your Honor. If we could go back and then everything can done the proper way, that I would like to do it too, Your Honor.
All right, let me shift before your time runs out. I had a couple questions about some of the evidentiary rulings of the district court.
Yes, Your Honor.
So apparently there was a joint stipulation of facts. Is that correct?
Yes, that's one, Your Honor.
But the district court excluded that and said it was cumulative. It's the first time I've heard of a joint stipulation of facts being excluded from evidence. So help me understand why that was appropriate.
Your Honor, the answer is I don't know. I think at that time he wanted to present that, and the judge ruled that that's not necessary. There's other evidence both parties can present it, and also that I don't remember clearly under what circumstances we have that joint stipulation. But I think the court would rather to hear the raw evidence or testimony from both sides. So they decided not to use that pre-agreed, stipulation, which, could work in his or my favor in either way. But he said it's worked in his favor. But I will argue could it work in my favor too.
So there were some texts that were excluded where Mr. Key says, you gave me a very generous gift, and your client says, don't mention it, I hope you're happy. There's nothing in that or these other text exchanges that says anything about a marriage contract or changing title to the house. I mean, those would appear on their face to be, party admissions against interest and admissible as an exception to the hearsay rule. Am I missing something there?
You are exactly correct, Your Honor.
So you're agreeing the district court erred when it excluded those texts?
I think I object on the hearsay rule and the court ruled, against him. So, I mean, again,
I understand that that's what happened. What I'm asking you now is whether the district court made an error when it did that.
I think you are correct, Your Honor. Yeah, he did. Yes, he did.
Okay. All right. Well, you've got a couple minutes left. What else would you like to tell us?
Your Honor, and also based on this court precedents, I don't believe there's any due process violation. The thing I really want to say is that we are living in this case went on for a long period of time. My client is totally stressed out, and this case is about marriage, and basically it's about a relationship, right? Where there's a relationship or not. And it's up to both sides to present evidence to the court that where there's a relationship, what is the money for? What's the money being transferred, authorized or unauthorized? What's the purpose of the money, right? And then the court make a determination. So there's there are three remaining claims. The defendant won one of them, I won two of them. And the jury issued a verdict. I think after the jury heard the entire story, jury reached the verdict. Both sides' story was wrong.
You said you won two. I thought breach of contract was.
Oh, no, I apologize. I could won two. The jury come back with a question whether after they give my client the verdict for the breach of contract, whether they needed to continue to rule on the unjust enrichment claim, and the court says you do not need to. That probably, if that be appealed, probably that's.
But the jury only returned a verdict on breach of contract.
Yes, Your Honor, that's correct. So I think the jury heard the entire case and issued a verdict, and we respectfully request the court. To uphold the jury verdict. Thank you so much, Your Honor.
All right, thank you very, very much. We'll now hear Ms. Fox in rebuttal.
Good morning, Your Honors, and may it please the court. Margaret Fox, amicus on behalf of appellant Mr. Key. Opposing counsel wants you to think that Mr. Key was on notice of the core claim against him. But the facts alleged in the complaint and the facts stated at trial Again, the central premise of liability here could not both be true.
Now, let's just assume we agree with you on that. What are we supposed to do now?
Well, Your Honor, first we would address the harm that was done to Mr. Key by this change. Opposing counsel claims that there was no prejudice here, but he fails to grapple with the central premise that Mr. Key was entitled to know the core claim against him and be given a sufficient factual framework to guide his discovery. Here, Mr.
All right,
Key...
well, let's assume we agree with you. He was bushwhacked at trial. Obviously, he wasn't ready to proceed with that. But, in the ordinary course, lawyers are making objections. They're telling the district court, this is an error. Here's what we need to do. And we're having to kind of read between the lines for that. Somebody's going to have to write an order or an opinion saying what to do. And so now what's what I'm asking you? How are we supposed to go about doing that?
Yes, Your Honor. We believe, again, the easiest way to resolve this case is as an abuse of discretion under Rule 15. Rule 15B explicitly provides the process for amendment during trial. Now, there's been some discussion today about the duty of the district court here. Simply, the district court had a duty to follow the procedures of 15B1 and 15B2. If neither of those provisions can be met, plaintiff should not have been allowed to proceed. And opposing counsel...
What's your best case in a pro se situation where there's a reversal under Rule 15?
Your Honor, we do not have a case on point for a pro se under Rule 15, but central components of this court's case law, both under 15A and in its case law for pro se litigants, show us that this was a reasonable example of an objection and that this was a clearly prejudicial amendment under Rule 15. First, as a pro se party, we know that Mr. Key was entitled to have his objections construed liberally. This court has long acknowledged that pro se litigants are entitled to more latitude, and this was even acknowledged by the trial court itself in its motion for summary judgment. And
all right,
again,
well, let's say we agree with you on that, at least in theory. But when we're issuing opinions, we're obviously resolving the case before us, but they have an implication for a lot of other things. So it sounds like to me, under your theory, we would be telling district courts for the first time, whenever they have these cases, that they have this sua sponte duty to, in effect, act as counsel for the pro se litigant, which I think would come as a surprise to a number of the district court judges.
Well,
so
Your
you
Honor,
see the dilemma that we have in trying to make a resolution.
absolutely, Your Honor. But I think that the context here is important in that the district court was not raising this completely sua sponte. Again, Mr. Key raised his objection at several points during this trial. You can see this at the start of the second day of trial, at the beginning of his case in chief, during his own testimony.
When you say at the start of the second day of trial, what did he say at the start of the second day of trial?
I believe this is when they're discussing, he's trying to start his case in chief, and I believe he begins by he's making what appears to be an opening statement. And he says that he's doing that because he was ambushed with this completely new theory.
Okay, so that's the opening statement, and then he says something similar in the closing statement. And I raised earlier that he pointed out the issue directly to the court during the jury instruction charge. Were there other places where you would contend he directly raised the issue to the court as opposed to the jury?
Yes, Your Honor. We had citations in the joint appendix at pages 204, which again is the start of the second day of trial, where he starts.
But is that his opening statement?
No, Your Honor, I believe 204 was his opening statement. Then again, in the beginning of his own case in chief, That's at 208. In his
He
testimony.
said something to the court there, directly to the court?
Yes,
Or was that his, okay.
Again, in his own testimony, Joint Appendix 239, and in his closing at Joint Appendix 256. So
Yeah,
we've
but
got,
that's, the closing is to the jury. I was just asking about when he was directly addressing the court.
yes, Your
So
Honor.
it sounds like you're saying during the jury instruction charge and his testimony?
Yes, and then there was some discussion again at the start of the second day of trial. I cannot remember the context off the top of my head, but that's
Okay.
around 204 in the Joint Appendix.
Okay.
But again, we would contend that at all of these points, Mr. Key was making a proper objection under 15b1. The district court did not have to raise the objection themselves when under B1, Mr. Key raised the objection, or under B2, he clearly did not give any kind of consent to this. I understand that there is some difficulty in writing this opinion, but ultimately, Your Honors, this case should be reversed and remanded for a new trial. The theory was changed in the middle of trial, and after repeated objections by a pro se litigant, the trial judge decided to continue on an unpled prejudicial theory. This was an abuse of discretion under Rule 15.
Okay, yeah, and on, just to confirm, on JA 204, what you were talking about is when Mr. Key approaches the bench, they're arguing about evidence, I think, and he approaches the bench and says, I've been fighting this whole thing, and to my surprise, they changed the testimony, they changed the theory yesterday, basically, something like that.
Yes, Your Honor, that is one of the citations we had for his change, for his objection.
All right, thank you very much, Ms. Fox. I want to convey on behalf of the court to you and to Ms. Forbes the court's appreciation for undertaking representation in this case, and compliment all counsel on their arguments. We're going to take it under advisement, and unless my colleagues would like to take a break, we're now going to move to our last case here in about a minute.
Thank you so much, Your Honors, and have a great day. Stay warm, stay healthy. See you next time. Thank you.
All right, thank you very much.
This honorable court will take a brief recess.
Yes,
Okay, all right, Delaney, if you want to bring up the next case.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
There we go, we've got all the lawyers now. All right, our next case is Skidmore versus Schink. Mr. Strelka, we'll hear from you.
Yes, may it please the court. My name is Thomas Strelka. I represent the appellant, Mr. Skidmore. This is a unique matter. This is a matter that was originally filed in the Circuit Court of Allegheny County. It was a matter that was filed against two non-diverse defendants, citing a single claim of the public policy Bowman claim, a common law claim. After removal to federal court, the appellant sought to remand by filing a motion to remand, and the appellee filed a motion to dismiss under Rule 12, and the matter then came to a hearing, and the court agreed with the appellee. We appealed. There are essentially, well, the main issue in this case is the statute that the plaintiff, the appellant cited in his complaint. That statute 40.1-28.7.
I'm assuming based on the supplemental briefing, et cetera, that the parties are in agreement that essentially if there is no Bowman claim, then there was fraudulent joinder and that's it. Is that correct?
That's correct. If there's no Bowman claim, then, I mean, that's it. That's the whole case.
All right,
And-
so why don't we cut to the chase? Tell us why you have a Bowman claim.
Well, there are 3 reasons why this statute may be used as public policy. First is the statute itself. 40.1-28.7 says that no employer shall discharge from employment or take other retaliatory action against an employee because the employee essentially inquired or discussed issues of compensation. The next issue we go to related to the jurisdiction of the federal court on this matter is whether this statute provides what's known as an exclusive remedy to the appellant. If, according to the district court, it does, and if it does so indeed, then the plaintiff doesn't have the appellant doesn't have a case. The court erred in its interpretation of the case law it cited in finding that 40.1-28.7:9 was an exclusive remedy. And Virginia's history with the Virginia Human Rights Act also demonstrates and supports the conclusion that this act does not provide an exclusive remedy.
But you agree there is a remedy in the act?
No, there is no remedy for the appellant in the act.
Well, what's your best case that that's a requirement that the Supreme Court of Virginia has set? Because there's clearly a remedy, which is for the Commissioner of Labor to seek a civil penalty or to petition a circuit court. So there is a remedy. I take it your argument is, well, just hold on, counsel. I take it that your argument is that there has to be a personal damages remedy for a particular plaintiff in order for there not to be for the Bowman exclusion to apply. Have I got that correct?
Yes, Your Honor. That's what Virginia has held prior. That is what the case
tell
law.
Tell us what your best Virginia case is that says you get this private damages remedy.
There are 2 issues, and when you look at the cases, you also have to look at the laws too. So, for instance, the district court cited a Fredericksburg Circuit Court case, Jenkins versus Hellig-Myers, and that case weighed another statute, 40.21-51.2:2. And that court and the district court looked at that case and determined that that statute does provide a exclusive remedy. That statute, 40.21-51.2:2, provides a private right of action. And that is a big difference because the statute that the appellant in this matter has pointed to provides no private right of action. If you look at the Virginia Human Rights Act and how the General Assembly and the Supreme Court of Virginia have regarded it over the years through its amendments, it's very clear how this court should rule. When the Virginia Human Rights Act was enacted, it initially didn't have a private cause of action, a private right of action. It allowed similar to this statute, the commissioner of the Department of Labor to take action. That's what the Virginia Human Rights Act used to do before it was amended to allow a private cause of action. And in the Supreme Court case of Virginia Lockhart, that court determined that there was a public policy in the Virginia Human Rights Act against discrimination, and there wasn't a private right of action in the statute at the time. Therefore, the plaintiff in that case, in Lockhart, could use the Virginia Human Rights Act as an indication of public policy of Virginia, just as the plaintiff did here. Now, the General Assembly recognized this and the Lockhart decision, and they amended the Virginia Human Rights Act in what was called the Lockhart Amendment. Again, this was the previous Virginia Human Rights Act, but they amended it with a subsection D. The previous code section was
Right,
2.1.
My colleagues may not be familiar with it, but as you can guess, I am. But that statute did not have an equivalent prior to amendment of the subsections B and C we have in this case.
But that statute, what the differentiating factor was the private cause of action. The General Assembly had to specifically go back and enact legislation amending the Virginia Human Rights Act to specifically say the public policies in here are, cannot be used for a Bowman claim. It wasn't the specific words, but it was specifically addressing the decision in Lockhart. The General Assembly had the ability to enact language to separate the Virginia Human Rights Act from the contemplation of a Bowman claim, and no such legislation was enacted in the current statute that was enacted in 2020. The General Assembly could have stated, just like in the Virginia Human Rights Amendment, that any public policy stated in here is not to be used for a Bowman claim. They never did. They never did. Because there is no private right of action available for a plaintiff under this statute, it can't be said to provide an exclusive remedy. I'd like the court to consider an analogy of a car accident. Imagine Mr. Skidmore, the appellant in this case, was in a car accident.
Doesn't the Department of Labor website have a form on it for employees to make a retaliation claim? It says
There may be a form on the. Sorry.
It says if you believe you have been affected by an act of retaliation specifically related to wage sharing, and it cites the statute, please complete this claim form. And then there's a claim form to complete.
There is no remedy. There may be an outlet. What can the plaintiff receive? Under this law, nothing. They receive nothing. There's nothing in that form or on the information provided on any Department of Labor website that shows the plaintiff can be provided with anything. And that is the key difference. Because what remedy does a plaintiff have if they're not offered anything?
So what about that subsection C, though, of the statute? I don't know if it's ever been utilized, but it says the commissioner can petition the circuit court for an injunction. That would seem to give a claimant relief, at least in equity, and such other relief as may be necessary, which would seem to imply there could be some sort of a damages remedy.
Certainly doesn't specifically say that there's a damages remedy in subsection C.
Right.
And subsection C could be limited to an injunction purely with the offender, between the commissioner and the offender. There's no language that within subsection C, the petitioner, appellant, or plaintiff is ever even incorporated into that proceeding. There's also no means by which they can themselves initiate such a proceeding, not under the statute. It is not clear that it can ever happen. So again, I'll be very brief with this metaphor, but if this was a car accident, it would be as if Mr. Skidmore could never sue or have any private cause of action if he was victimized in a car accident. But law enforcement could issue the other driver a citation. That is not a remedy. In that if the Attorney General could file an injunction against the other car driver, fine. It's pretty open-ended, that's sure, but that is not a remedy in itself for that plaintiff. This statute, the statute that the appellant in this case pointed to, is clear that has absolutely no private cause of action for the plaintiff. Can never initiate it. And that was a key distinguishing factor in these other cases. In the case that the district court itself hinged its decision on, this Fredericksburg court, that law has a private right of action. This law does not.
Counsel, can I ask a question here? And I guess I'm asking it in a way that is slightly different than whether you ultimately show you have a Bowman claim. I mean, the claim here is fraudulent joinder. And it seems like, that one of the defendants is a Virginia resident. And the way we're looking at this is, do you have a Bowman claim? And I get why that ultimately would be the answer. I guess what I'm trying to figure out is, for purposes of fraudulent joinder, do we have to, do you have to convince us that you have a Bowman claim, or is it essentially so weak, so impossible, so almost frivolous that it amounts to fraudulent joinder? And if so, whether we're the court that should decide that, or whether it should go back to the state court to decide that.
Great point, Your Honor. According to the Fourth Circuit cases of Marshall and Mays, the removing party always bears the burden to show that a non-diverse defendant has been fraudulently joined. And that removing party under Marshall must show that there is no possibility that the plaintiff would ever be able to establish a cause of action. And so that burden is on the other side in this case. It is the appellant's position that this matter should be reversed, that it should be remanded, and the motion to remand that the plaintiff appellant originally filed very shortly, within I think a day or two after the notice of removal, should have been granted. And the matter sent back to the Allegheny Circuit Court, because it's a state common law matter with non-diverse defendants. And this is a jurisdictional issue, so these matters can be discussed, of course, on appeal. I don't have too much time. The issues in this case are pretty narrow. I've been in front of the Fourth a number of times, and I've had some kind of expansive cases on summary judgment with lots of facts. This is really narrow. This is whether 40.1-28.7:9 provides an exclusive remedy when it doesn't provide any private right of action to any plaintiff. So it can't be said to have an exclusive remedy. If it can't be said to have an exclusive remedy, then it can be a public policy used for a Bowman claim. And the elements, the prima facie elements of the retaliation of a Bowman claim are within this complaint. It alleges that both the appellees involved in the decision, suspension, and the retaliation. So I'll reserve the rest of my time for rebuttal and let my colleague across the aisle take the field, but I appreciate all of your time today. Thank you very much.
All right, and I take it, Mr. Strelka and also Mr. Gordy, nobody wants certification to the Virginia Supreme Court. You all want us to decide it.
Yes, Your Honor, and at the risk of speaking for my counsel across the aisle, I think both of us would say that there is enough information before the court for the court to rule on this issue from both parties. But I think both parties would also say that if the court felt otherwise, that it should be certified. We understand why the court would weigh certification on this issue as a matter of state law. On behalf of Mr. Skidmore, who is a man without great means, this matter never went through discovery. It's been going on a while, through no fault of Your Honor's, of course. But moving it to the Supreme Court of Virginia would require additional time, briefing, and expense. And we believe that the matter is briefed sufficiently for this court to render a decision, and we thank you for that consideration.
All right, thank you very much, You've got some rebuttal time. Mr. Gordy, what do you say?
May it please the court, Timothy Gordy on behalf of appellees Michael Schinke and Gail Saul, and I'm honored to appear before your honors this morning. This court should affirm the district court's order finding fraudulent joinder and dismissing Skidmore's complaint, which raised a sole wrongful termination claim under Bowman. Bowman represents a narrow exception to the at-will employment doctrine. Consistent with this narrow exception, a plaintiff may not proceed on a Bowman claim if they seek to rely on a statute that establishes an exclusive remedy. And here, Virginia Code section 40.1-28.7:9, which I'll refer to the Pay Transparency Act, contains such a remedy. An aggrieved employee may file a complaint with the Commissioner of the Department of Labor, who may impose a civil penalty or file an action in circuit court seeking an injunction or other appropriate relief.
So how would you respond to Mr. Strelka's argument based on the Lockhart case, which interestingly, the author of Bowman, Justice Compton, dissented in Lockhart, but it's a 4-3 decision. It's the law of Virginia. Why is his argument on that incorrect?
I believe it's incorrect. You, Judge Agee, during his Mr. Strelka's argument, pointed to subsections B and C, which provides the civil penalty and provides the right for the commissioner to file this action for an injunction or other appropriate relief. And under the pre-1995 regime, there was not that enforcement mechanism. And then after we have the Lockhart decision, the General Assembly amends the statute. It inserts the narrow statutory remedy against an employer with between 5 and 14 employees. And then the Supreme Court considers that amendment in Doss, finds that this exclusive remedy, and is now abrogated Lockhart. So I believe that the subsection B and C, which provides this remedy, and the default rule that the Supreme Court of Virginia has held is that when a statute provides a remedy, that remedy is exclusive unless the statute says otherwise. And we believe those holdings control here. While the Supreme Court has not interpreted the Pay Transparency Act, the Court of Appeals' recent decision in Bowserman confirms that Skidmore may not bring a Bowman claim. There, the plaintiff employee sought to base his Bowman claim on his utilization of this grievance procedure for local government.
Bowserman is an unpublished opinion. How much credence does it get?
We believe it is persuasive authority, Your Honor. It applies the binding Supreme Court holdings. It cites to concerned taxpayers, which again holds this. The statute provides a remedy. That remedy is exclusive. And even though it's persuasive, this goes to the Geelan matter that we cited in our supplemental brief when the I think it's the Maryland Court of Appeals at the time had not addressed the issue before the court, but the Special Court of Appeals had in unpublished decisions. This court deferred to those decisions in the lack of any persuasive authority to go against Bowserman. And we believe Bowserman is persuasive for the reasons that we discussed in our brief.
Counsel, if I could chime in here, I mean, is it possible that as we look at, we're looking first at the fraudulent joinder decision, that you could have the better end of the argument, but it's still, we don't have a case that absolutely rules out what the plaintiff is saying. We don't have a case that's a Supreme Court case on the particular statute. Correct me if I'm wrong here, I'm not sure I saw a cite to a case that specifically says if the remedy in a statute doesn't provide the victim relief, that would nevertheless bar a Bowman claim. And look, I think the way you look at the cases suggests it does, by the way. But what I'm trying to figure out whether it's so clear that we would call this a fraudulent joinder. And if it's, because it's a different standard, a more rigorous standard than 12b-6. And I'm just wondering whether it meets that, and if not, whether we shouldn't remand it for the Virginia courts to deal with it.
Your Honor, I believe it does qualify as fraudulent joinder because as Mr. Strelka himself admits, if he doesn't have the Bowman claim, then there was fraudulent joinder.
Is that right? I mean, he may have admitted that, he shouldn't have, because the question is not, does he ultimately have one? It's because he might not, but does he have a chance? Does I have a claim? It might be weak, but I got a chance. I mean, sure, if he doesn't ultimately have one, he loses. But as I understand, tell me I'm wrong, I may be missing that, but I think the question is, he may not have a Bowman claim at the end. Quite frankly, he probably doesn't, if you ask me. But he's made some arguments that I'm trying to see if they're foreclosed. And if they're not foreclosed, why is it fraudulent?
I think they're foreclosed for the reason that the Court of Appeals held in Bowserman. In that regard, that there was a statutory a grievance procedure that the employee could utilize. At the end of that grievance procedure, there was very limited ways to get to the circuit court. It usually dealt with administrative issues in the grievance procedure, like whether it was grievable or whether there was a procedural error. They didn't have...
I think Judge Quattlebaum's question goes to the standard for fraudulent judgment or fraudulent joinder.
Yes.
So we realize there are a lot of these cases out there. The Virginia Supreme Court's been pretty clear that they have serious doubts about Bowman, but that doesn't necessarily resolve the fraudulent joinder issue. Why is this clear beyond doubt?
I think it's clear beyond doubt because the Supreme Court has consistently held that when a statute provides a remedy, that remedy is exclusive. And I think the Doss decision, which abrogated Lockhart, and then the Court of Appeals decision in Bowserman, which applied these Supreme Court cases and found that the fact that the statute precluded the termination, the retaliation claim, showed it could not be the public policy to base a Bowman claim on, because to do so would subvert the statutory scheme the General Assembly created. Bowman is a narrow exception to the at-will doctrine. The Supreme Court of Virginia has been very clear that just because there is a statutory violation, that the plaintiff does not have the right to bring a common law wrongful termination claim. And if you look at the case law, Francis, very clear, it's a very narrow doctrine in Van Buren v. Grubb, again, emphasizing this is a claim against individuals, and it is a very narrow exception, and it's almost even, it is more narrow in this context because there has to be the showing that the individual defendants also participated in the termination decision, which goes to our alternative argument under Wyman, which if you set aside this issue
But the district court didn't address any of those alternate arguments.
Correct, Your Honor. The district court did not address it. We believe they're clear, especially under Wyman, that this court can address it. There's just simply no allegations here that the appellees participated in the wrongful termination decision. He says that Mr. Schinke reduced his supervisory responsibilities. He wrote this anonymous...
We're getting into the alternative arguments that, I understand you've made those, but arguments the district court didn't address. As I understand Mr. Strelka's argument, it's that there's no specific case that says that the exclusive remedy has to take into consideration a private damages claim for the claimant, and that's sufficient for fraudulent joinder purposes to get a remand. So we're kind of bringing you back to Judge Quattlebaum's question on when we're looking at the standard for fraudulent joinder, is the lack of this precise a case as this claim would require, does that meet the fraudulent joinder standard?
I believe, Your Honor, we meet the fraudulent joinder standard, even though there is not a specific case from the Supreme Court of Virginia that would foreclose a Bowman claim in this scenario. We're relying on the general holdings of the Supreme Court, and then I think the Bowserman decision really confirms that when it applies those precedents very recently and holds that you cannot bring a Bowman claim if the statute provides for an exclusive remedy. And here, there is an exclusive remedy under the statute. It's subsection B, the commissioner can impose that $100 civil penalty. The aggrieved employee has the right to file a complaint with the commissioner of the Department of Labor. And under C, the commissioner of labor can seek injunctive or other appropriate relief. And that relief would be personal to the employee. An injunction could order reinstatement. Other appropriate relief, as you mentioned, Judge Agee, would cover back pay, for example. You could also get an injunction to prevent an employer from retaliating if they simply threaten.
Well, I think the point is that this is different. If I were back on the Virginia Supreme Court, I'm pretty sure how I would rule in this case. But now we're dealing with a federal standard for fraudulent joinder. And the fact that you don't have an on-point case, that's the question in the federal joinder standard as to whether or not that's absolutely necessary.
I do not believe it is absolutely necessary, Your Honor. I believe that we can rely on the holdings that are currently on the books in terms of the Supreme Court's emphasizing that this is a narrow exception to the at-will doctrine, the Supreme Court's consistent holdings that when the statute provides a remedy, that remedy is exclusive, and will rely on the Court of Appeals decision in Bowserman, which applies those holdings in a very similar case to ours.
All right. What else do you want to tell us today?
In terms of the personal remedy argument that Mr. Strelka makes, there does not need to be a personal remedy for the statute to be found exclusive. And I believe the First American Title case, which was the old version of CRESPA in Virginia, only the state licensing authority could bring a private right of action. That was found to foreclose a common law cause of action. Mr. Strelka cites to Cherry in his brief, and we think Cherry supports our argument because in Cherry you had a very similar statutory scheme where in that case the nursing home resident could file an administrative complaint. There could be administrative sanctions, and then the health commissioner could bring a cause of action in circuit court to show that to enforce the statute and regulation. And the Court of Appeals held that that was an exclusive remedy. There would be no common law cause of action to enforce the statute. I think he also relies on Dominion Surgical, which I think the court there, we pointed out there's some disagreement among other courts, but a key factor there that court looked at was that there wasn't this ability to participate in the administrative process, where here there is that ability. The complainant has the right to file that complaint with the Commissioner of Labor, who investigate, impose a civil penalty, and then file a cause of action under the statute. Also would like to talk about, I know I briefly touched upon this in terms of the Weidman argument under Weidman. We also believe there's factual deficiencies here in terms of what Mr. Skidmore alleges in the complaint. And in Weidman, again, I recognize the district court did not address this. This would be one of our alternative arguments. The factual allegations here are very similar to that in Weidman, where this court did affirm a finding of fraudulent joinder. You had a Bowman claim against two individual defendants. In Weidman, the plaintiff alleged that they participated in an investigation into a complaint and they attended his performance meetings. There were no allegations connecting them to the termination decision. And this court found there was no possibility under Virginia law that he could succeed against the individual defendants. And here, the complaint suffers from the same deficiencies. He tries to get around this by just conclusively saying the defendants terminated Mr. Skidmore's employment. But if you look at the facts of the complaint, he only alleges Schinke reduced his supervisory responsibilities, which that's not sufficient for a Bowman claim. He writes this anonymous letter that is then investigated by a different employee, not Mr. Schinke, and then after that anonymous letter is when he was terminated. As we pointed out in the first complaint that he filed in federal court, he identified Sunoco as the person who terminated him, and this would be something that Mr. Skidmore would know. He could have alleged that Mr. Schinke, Ms. Saul, wrote the termination letter or told me that I was terminated, and he did not make that allegation. So we believe under that as well that establishes there was fraudulent joinder.
So counsel, could I follow up on that? I'm just trying to, and this question isn't to suggest how I, and certainly not my colleagues, are thinking about it, but just hypothetically, let's assume that we thought that there was, at least some possibility that that under Virginia law, there needed to be a private right of action. And you have this other alternative ground that you've just articulated about a pleading inadequacy. We of course can affirm on any ground before us, but we do our best work usually reviewing rather than finding in the first instance. How would we deal with that procedurally? Would we remand it to the district court to consider all the arguments that you have made in the fraudulent joinder case? I know you'd say y'all decide it yourselves, but we'd have that option, wouldn't we?
I think under Weidman there is enough for this court to affirm on this alternative grounds. If you do disagree with me, Your Honor, I do not believe reversal is the appropriate course. It would be to allow the district court to consider these arguments. And I think that, again, under Weidman, which relies on the Supreme Court of Virginia's decision in Van Buren, that Mr. Strelka has not alleged enough in the complaint to meet that no possibility standard, which again, I understand the court's concern that there is not a direct case on point, but I think the appropriate look is to look at the case law.
Well, to be clear, counsel, the alternate bases that you're covering would be alternate grounds if found for fraudulent joinder.
Yes.
Because that's the only issue before us.
Both issues are before you, Your Honor, because we agree with Mr. Strelka. They are intertwined in the sense that the fraudulent joinder and 12b6 arguments are one and the same. It's all based, if he doesn't have a claim against Schinke, he does not have a claim against Saul. And the no possibility standard, this court needs to, should look at...
Well, if there's no fraudulent joinder, wouldn't it have to go back to the state court?
Correct, Your Honor. I meant in terms of that the legal issue before you on the two is the same. The no possibility standard, this court must look at the case law and make
let me make sure I understand what you're arguing. Are you saying that your alternative arguments are or are not alternative grounds to find fraudulent joinder?
They are alternative grounds to find fraudulent joinder, Your Honor.
Okay. All right. Thank you very much. Mr. Strelka, you've got some rebuttal time.
Thank you, Your Honor. I appreciate all the questions that Your Honors have been asking. The key issue is fraudulent joinder, and the removing party must show there is no possibility that the plaintiff would be able to establish a cause of action. If the court were to remand on that, reverse that, and say that there was no fraudulent joinder, and Your Honor is right, Judge Agee, the district court would have to remand it to the state court if there is no fraudulent joinder.
Why couldn't
Opposing
they go
counsel,
after it?
wait a minute, opposing counsel says he's got these other grounds that would qualify, I don't know whether they do or not, but if there were other grounds for fraudulent joinder and they were found to be sufficient, then the district court's decision would be right. So, but if we were to find for you on what's before us right now, it would seem like there would be a vacate and remand for further proceedings for the district court to take up in the first instance, whatever these other arguments are.
That's a possibility, Your Honor. The court is still going to have to wrestle with, whether if a prima facie case has been pled, and if so, then they don't have jurisdiction. The federal court would not have jurisdiction at that point. Because my understanding, these alternate arguments really just attack it from the 12b6 standard. I want to briefly mention the Bowserman case, which my colleague across the aisle has mentioned a number of times. That case, the policy and the statute that it used was that the grievance statute, and that again is also highly distinguishable. That is 15.2-1507. That's what the Bowserman case was reviewing. That statute allows an individual, a plaintiff, an employee, to initiate the entire proceeding, which it is a proceeding, on their own, not through a third party, and they can receive the remedies of reinstatement or a variety of remedies and seek judicial review of these decisions, allowing that plaintiff the ability to elect on their own to review the entire decision that they have also elected to proceed in a circuit court. None of that is here with this law. So if my colleague wants to cite the Bowserman case, I have to highlight those issues. This court cannot say that there is no possibility that the plaintiff would be able to establish a cause of action under Bowman. The court just can't say it. And for that reason, this court must reverse the district court's decision. I appreciate everybody's time on this very nuanced and specific issue, and we look forward to the decision. Thank you very much.
All right. I want to thank both counsel for their arguments. We'll take this under advisement and issue an opinion in due course. And I'd ask the clerk to adjourn us until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.